Good afternoon. Welcome everyone to the National Justice Project's inaugural Law Hack 2021 Disability Justice Pitch Session. I'm Stephen Caston. I'm the chairperson of the National Justice Project, and I'm joining you today from the beautiful lands of the Bunurong Boonwurrung peoples of the Kulin Nation. My co-host and colleague is Ariane Dozer, and we will together be guiding you through this afternoon's event. Ariane is a proud Gaieri and Butchulla woman, solicitor, and the Projects and Partnerships Manager at the National Justice Project. Today, 10 teams of bright minds, passionate hearts, and brilliant professionals from the legal community and advocacy sectors have been collaborating to come up with groundbreaking strategies to tackle the 5 key injustices facing Australians living with disability. It now gives me great pleasure to introduce Auntie Glendra Stubbs, Elder in Residence at the Jumbana Institute for Indigenous Education and Research, to acknowledge country. Over to you, Auntie Glendra.
Hi, can you hear me? Okay, thank you. Yalamanut Marang Galindera. I'd like to say I'm really honoured to be able to be here today and to have done the acknowledgement earlier on. It's such a privilege to be the Elder in Residence, and I've done some pretty amazing things in my life, you know, with the Royal Commission and No More Legal Service, so giving a voice to the voiceless, and a lot of our clients have been people with a disability. I'd like to acknowledge by acknowledging to country and start by paying my respects to the traditional owners on the land we virtually meet and say thank you. I'm on the land of the Darug and Gundungurra people, overlooking the beautiful Mount Hay. I've lived here all my life, so it's really special. It's my belonging place. I also want to pay respects to Aboriginal people for their custodianship of country and of elders past, and acknowledge their struggles, and our emerging elders, and pay respects to our non-Aboriginal brothers and sisters who walk with us and hold our hands in truth, justice and healing. As somebody who's had my own issues with mobility, I always have a little story, and you know, so I had an accident, and so I had a cart for a long time, and so I to go onto the train in the mountains, there was 69 steps, and there was no lift until we got to Blacksland. So that was ages away, and I thought, you know, this is just dreadful. And then when I got to work finally, I had to walk through the garbage dump because I couldn't get up the 21 stairs. So I have great respect for anybody with mobility issues, but great respect for anybody that is vulnerable and not treated as they should be in this country. I hope the groundbreaking legal solutions are there, because I've worked with some amazing young, hardworking, passionate, patient lawyers who are, like I said, social justice warriors. And, you know, one thing that's become really evident to me is that people promise things about disability. They promise funding, they promise changes, but everything takes so long. Like, I remember when my daughter told her story about at the Royal Commission into Disabilities, and things were promised, like IDRS was promised more funding. Well, I think they've had their funding cut. You know, people, so there's not respect. And also, you know, the Children's Court, they tried to change things for people with disability, but they can't get funding for a researcher. So change has to also come with a bucket of money, and not as an add-on to people that are already working so hard. So I just want to say, you know, sorry for the little bit of a rant, but, you know, today I also heard that a special needs school hasn't got funding for a nurse for medical things. This is not, you know, 60 years ago. Like, this should not be something people are fighting for. It's basic human rights for everyone. So so honoured to be here. Keep up the good work and keep on fighting. Big auntie hugs to you all.
Thank you so much, Auntie Glendra, for that warm welcome, and particularly for sharing your personal reflections. And, you know, you couldn't have said it better. It's absolutely spot on, everything that you said. So thank you very, very much.
And thank you, darling.
I'd now like to introduce our judging panel. And we are very honoured to be joined by 5 incredibly passionate and talented disability advocates today. And I'd like to formally welcome and introduce Dr. Scott Avery, Graham Innes AM, Margarita Coppolino, Natalie Wade, Rob Silverstein. Yes. Thank you all so much for being here. And each of our judges are going to assess each of the team's strategies against some core change criteria. The strategies that are going to be shared with us very shortly must demonstrate courage, humility, and they must be achievable, novel, and grounded. And we thank you all so very much for being here.
So we're now going to have the probably most exciting part of today's events, which is a live pitch from each of the teams. Each of the teams have been told that they've got 3 minutes to deliver the pitch, and then the judges will have a few minutes to ask questions. The questions will be directed through a judge spokesperson, Natalie Wade, and we will ring a bell when you're about 30 seconds from your pitch ending, and that means you do need to wrap it up, and we will wrap you up if you start to go over. The idea is to be quite succinct and concise. So I would like to, sorry, I'll just turn my phone down. I would like to invite a representative from team number 1 to kick us off. Team 1's challenge was centering on police and incarceration of people with a disability. So I'm not sure who the representative is, but if they could.
Me, Rhiannon.
Okay, then you'll go for it. We'll start timing you when you speak, and you'll hear a bell with 30 seconds to go.
We might just give a minute to have Rhiannon pinned, if that's okay.
Yeah.
Sorry, I'm just struggling to find people in the list at the minute. I'll pin as soon as I can.
Yeah.
No
All
worries.
right. Thank you.
I can see judges are pinned.
All right.
Excellent.
Maybe take it away, Rhiannon. Hey.
Good afternoon, everyone. I'm Rhiannon and I'm from Team 1, and our challenge statement that we've been allocated today is the policing and incarceration question. So during our research, we found a recurring theme that offenders with intellectual disability are more likely to receive custodial sentences than non-disabled offenders. We acknowledge that it's just not possible to remove the involvement of police at first instance, and we know that training is not a fail-safe way to protect people's rights. Our vision is to provide a legal reform to legally mandate the police to use a support person and social worker after an arrest has been taken place, to mitigate harm and to ensure that appropriate support is provided. This legal reform will provide protection to individuals with disabilities who come into contact with the criminal justice system. This will ensure that people with disabilities are recognised, empowered, their needs are catered to, and that safeguards are available to uphold their rights. Our legal strategy includes amending LEPRA, which is the New South Wales legislation for policing power police laws, which mirrors the safeguards set out in Part 9, Division 3 of the Act. This will legally mandate that the police and corrective services can use a social worker when interacting with people with disabilities. The social worker can assess if any vulnerabilities need to be catered for, including any disability needs. Now, linking to our legal strategy, our advocacy strategy focuses on targeting our campaign to the Attorney General, as well as having a petition to put pressure on the Attorney General. People with lived experiences will tell their stories to the media and on social media and to the Disability Royal Commission. This will holistically create a general awareness and mobilise people to put pressure to create this change. With regards to risks and limitations of our strategies, we understand that there are cost issues with relation to requiring social workers for all police stations and the difficulty in mobilising empathy about perpetrators of offences regardless of their disability. We also appreciate that further research is needed in relation to the utilisation of a model litigant and the application of legal reform, as well as the preferred method of identifying people with a disability and whether other states will follow New South Wales' example of implementing our strategy. We think that implementing it in New South Wales originally would be a great start, as we already have solid foundations of the perceptions and awareness that surrounds people with disabilities and their treatment within the criminal justice system, but we are hoping to eventually create our strategy in a more federal context. However, we do recognise that that comes with its risks and limitations, as it is quite a long process and does take time and is very expensive to undertake. We believe that our state-based amendments to LEPRA, along with our advocacy strategy, will allow us to effectively implement the use of support people within the criminal justice system to focus on that first contact response. We think that first contact is the most important way to reduce any further follow-up negative repercussions that may come as a result of people with disabilities being incarcerated or in the sentencing procedures that happen in court processes. Whilst there are some abilities at the moment, processes at the moment that are in place in the court sentencing processes, we think that by attacking the first contact response head on from the get-go, it will hopefully reduce the flow-on negative effects that can occur as a result. Ultimately, we must continue to strive for transparency across all levels of stakeholders involved with a sensitive issue such as this one, and we hope that our strategy can achieve that. Thank you.
Well done. Thank you so much. It's great to be able to hear how you are able to, when you we've ventured into the teams and to see it starts off so big and then to hone it down into a pitch. It's such a skill. I'd like to hand over to Natalie Wade, our judge's representative, if there are any questions that have been sent to her or she would like to ask for this team.
I will do, thank you, Steve. I'll give my fellow judges a moment to send me some questions. I have a question, Rhiannon. Why social workers? Why not disability advocates?
The way that we were thinking about it was the fact that social workers already have quite solid education processes in place to make sure that they are trained appropriately to deal with situations like this. We did go down the route of training police officers as well, but we think that that wouldn't be as effective as already implementing people that have that training already as a solid foundation to build upon that, rather than starting from scratch.
I'll open it to the other judges to ask questions directly just by unmuting and so Graham has asked, how would police identify people with disabilities, Rhiannon?
So that's another issue that we came across, because we did discuss the idea of potentially part of our solution being to improve data systems and have some sort of processes in place that when they do come across someone, the police do get called to a scene, they can then look up that person's details, and there potentially could be details about their disability available to the police officers. However, we did come across privacy issues with that, and also the fact that not everyone with a disability is eligible. So we were thinking of linking it to something like NDIS data that's already out there, but not everyone is eligible. Not everyone with a disability is eligible for NDIS. And we also had the pleasure of having Justin in our group who could share his story, and he didn't get diagnosed with disability until his 20s. And so that's another issue that came up with it. That is a limitation to our strategy at the moment, but we do recognise that further research is needed to explore a few more options and figure out what's the most effective, but also the most appropriate way to combat that issue.
Thank you.
In terms of the person who you say is going to help the police, to make informed decisions. Do you feel like you're limited by the number of or the kinds of people with the kinds of training that are available? Did you consider, for example, identifying a new kind of person with new training?
That's a really good point, actually. We didn't really think about having a new person. I think the whole point was the fact that having the social worker there removes any police bias. Social worker would also benefit other disadvantaged groups. And the whole purpose is to try and remove the police from having any role in identifying someone, because that just kind of furthers the disparities between the treatment of people with disabilities and people without that already exists. And I think that also comes back down to the fact that having education as a formal thing doesn't necessarily align with a lot of what processes are already in place. There's not enough resources for that. So at base level, we think it was the most effective idea to use social workers, for example, who already have that training skill in place and utilize those people in this new context.
Now, thanks, Rob, for the question. Thanks, Rhiannon. I'm going to be a bit of a nasty MC, and I'm going to basically allow, say, 2 questions from the judges, just because we've got time issues. There was another question in there from Scott Avery, but they could perhaps read it and type an answer whilst we go on to the next group, because we do need to keep things moving. We've got 10 groups. So thank you so much, Team 1. I'm going to move to Team 2, Healthcare, Disability Support and Aged Care. And we've got Samantha, who's going to present their 3-minute pitch.
Samantha, your microphone.
Hi, and thank you. My name is Sam Connor, and our pitch is about the vaccine rollout for people with disability. It's fair to say that the vaccine rollout for people with disability has been an abject failure. We want to make sure there are no barriers to accessing vaccines for 3rd doses, that there are booster shots for those that need it, and that everybody who wants to be vaccinated can get a vaccine. The Senate Standing Committee on COVID-19 on the 20th of April 2021 revealed that vaccinations to people with disability were deprioritised to prioritise aged care residents. This was revealed 6 weeks later and wasn't communicated to stakeholders. We don't want this to happen again. Our campaign is called Vax Me In, and we want to make sure that people with disability are prioritised in the vaccine rollout and that nobody is left behind. What are we going to do to make that happen? We have a two-pronged strategy, a legal strategy and an advocacy strategy. Our primary legal strategy is to prosecute the test case of a young Aboriginal woman with a significant disability who was not vaccinated and died in her group home. The family is suing the federal government for negligence and breach of duty of care. There are precedents there for asylum seekers and others. Our primary objective is to highlight the federal government's lack of action, not necessarily to win the case. Our Vax Me In advocacy campaign will run in tandem with our legal strategy and will leverage off the federal election. We're seeking to get a commitment from all of the major political parties that every person with a disability will be prioritised to be fully vaccinated, including with a 3rd dose. We also want to make sure that the recommendations in the Royal Commission report are upheld. The campaign will include a significant social media presence with the hashtag #VaxMeIn, a petition about the young woman who died, and a series of activities to empower people with disability to tell their stories and take their own action. It will be co-designed with a group of disabled spokespersons who represent the full diversity of people who are at risk, including Aboriginal people in regional and remote Australia, people with intellectual disability, and people in jails and boarding houses. This is how we're going to do it. We're going to launch a series of hard-hitting actions, including an open letter from people with disability, their families, academics and professionals, as well as a petition and a complaint to the UN under the CRPD. We came up with this name in recognition that people with disability are segregated, isolated, and live in places that many non-disabled people have never gone before. We want a commitment from the federal government that all people with disability will be vaccinated and safe in the COVID pandemic. And so I leave you with this quote from Star Trek: "Things are only impossible until they're not. Vax me in." Thank you for listening to our pitch. Under 3 minutes.
Well done. Make it so, as one famous Star Trek captain used to say. Judges, thanks for that, Samantha. Judges, 2 questions And perhaps if you have more, put them in the chat. Vax me in. Catchy.
Thank you, Rochelle, for having the Star Trek theme playing in our heads for the rest of the day.
Natalie, I have a question. What is the likelihood of the case getting to court before the rollout of a third vaccine?
So given that because we talked about timing and the likelihood of this getting to court, we took into account that quite often the media that's generated around taking someone to court, that launching that action is actually the important part of it, and that's why we didn't factor this in as a successful case being part, crucial to the overall strategy, because of course it's a time limited issue. We're trying to save people's lives. We want to make sure that that people really have got more of an awareness that people are at risk right now, and that we can unpack some of the really tricky situations at the moment. So it was really hinging on using that action in an advocacy sense as well as in a legal sense. But we also hope that, whatever happens as a result of this would make sure that the federal government were not only galvanised into action now, but also considered their duty of care for the future.
Another question from the judges.
There's one from Scott in the chat, Steve.
Okay, would you like to read that, or would you?
I'm happy to ask it in person. I just how your legal strategy, knowing the timeframes involved in that, how does that deal with the here and now imperative of getting vaccination rolling now, I guess?
Yeah, and I guess it's almost the same as Graham's question as well. It's really just about making sure that we have a series of actions, and we considered the legal, because we had this timeline issue, that the legal reform, whatever comes out of this, will be something that we're using advocacy hand in hand and in tandem with this in terms of making direct change. So, yeah, we were hoping that making sure that we've got people being aware of, that people with disability have died as a result of this, and what the vaccination rates a few weeks ago, it was 4.8% of people, of children between 12 and 15 who were vaccinated, which is pretty shameful. 72% of people who died last year were people who had an underlying condition. So a lot of people in the mainstream population aren't aware that, disabled people, including disabled people who are disabled as a result of age, are at risk. So it's really making sure that those issues are brought to the forefront, and we just keep the pressure on government, and using that legal tactics are part of that as well.
Thanks so much, team. Well done. And thanks, judges, for your questions. We're now going to keep moving because we're on a little bit of a time thing here. So we're going to go to Rights and Law, Team 3. Now I've got Bridget or Daniela. I'm not sure which person it is.
Me. Sapphire. So it's Saph.
Oh, okay. That's completely okay. So thank you so much. All right, your time starts now. Team 3, Rights and Law.
Great. Yep. So my name is Safia Grant. I'm calling in from stolen Muanina country. I'm here in my capacity as a project manager for WIDA and as a person with disability. So the question was, how can we protect the rights, dignity and autonomy of people with disability by eliminating violence such as coercive involuntary sterilisation and restrictive practices? So what our vision was is we seek to protect the rights, dignity and autonomy of specifically women and girls with disability who are the most affected cohort who experience violence associated with coercive and involuntary sterilisation and restrictive practices. We want to see forced sterilisation outlawed and women and girls with disability to have full and equal access to sexual and reproductive health support and services. So our advocacy strategy, we're going to start first. And I want to acknowledge Arnie Gendra Stubbs as we essentially have been asking for more funding in this area, and that's our advocacy strategy. We want to lobby and argue that the Australian government needs to actually, in consultation with people with disability and their representational organisations, to develop a national strategy to improve access to and implementation of cohesive, equitable and accessible and disability inclusive sexual and reproductive health and information, with a particular focus on improving and the access to such information for women and girls with disability, regardless on which setting they work, live or study. This means setting up fully accessible co-design committees with people with disability, developing in consultation accessible resources, investing in the individual capacity building of women and girls with disability to engage in decision-making, improving public access, entrenching into social, economic and political systems, the human rights of women and girls with disability, to have equal access, including access to sex therapists through the NDIS, and immediately revise the National Disability Insurance Scheme, the Supports and Participants Rules in 2013, to ensure explicit provisions for NDIS participants to access funded supports that enable them to realise their rights to sexual health information, sexual pleasure, expression, association, freedom, autonomy, and self-determination. So our primary targets would be the federal ministers. Our secondary targets would be the state ministers and disability health and the women's ministers. And we would partner with advocacy groups like Parenting on a Mission, and also the DPOs and other organisations within the disability, women's and justice sectors. So our legal strategy is that we propose in bringing a claim to the Federal Court of Australia with a factual scenario that a woman with disability who's been experiencing chemical restricted practice of implant under the arm, who didn't give fully informed consent to begin with, and it was implanted with not enough sufficient information to give fully informed consent, and the side effects and how long they would last. So the contraceptive lasts for 5 years, and we're seeking funding for it to be removed because it suppresses her sexual desire and gives her depression and low libido. So she has a long-term partner, wants to have children, and as a family, and the family don't want it removed. She's also, so we're also looking for funding from the NDIS for IVF basis that her fertility may have declined because of the implant. So the legal basis for the claim has two parts. Well, a few parts actually. We have the claim against the doctor who administered the implant because of lack of informed consent. This means that there's been a trespass on the person's professional negligence. The claim is also challenging the concept of consent as a legal test established for able-bodied people. A person with disability has human rights which are not articulated within the concept of the current legal definition of consent. The NDIS application. Here there's a precedent with the National Disability Insurance Scheme versus the WRMF 2020 claim. And we claim that the support claim for the IVF is reasonable and necessary in the circumstances of the applicant. We also have a human rights-based claim, which NDIS is intended to implement the Convention of the Human Rights of Persons of Disabilities, which includes sexual rights within the concept of human rights. And we're going to fund this through the pro bono firm taking on the case, much like what happened with the Let Us Speak campaign, and also through a really successful crowdfunding campaign, because I hope that this pitch to not only impress all of you who are wonderful colleagues, but also all of our funders who are going to just jump on board because it's a really good campaign.
Thank you. Thank you.
And I want to thank Daniela from Scope for the wonderful background that she came up with creatively for this pitch, and my team for putting a person with disability up the front and really envisioning and also making me feel so welcome and as a really great part of the team, and there's so much respect and such. Yeah, I'm just so honoured to be here.
Thank you so much. And I'll just open it up. Yes, lots of emojis. Please, everybody use emojis as often as possible, good ones. So I'll just open up to the judges for 2 questions, and just for everyone, including myself, and is just to remember we do have Auslan, and so we just need to just a little bit slower. It was brilliant.
Sorry.
No, you're brilliant. It was fantastic. Just
I was a bit nervous.
Yeah, I know. I am too, and it doesn't look it, but I am. And I got slowed down at the very beginning of the day by my fellow team members, so don't be embarrassed at all. But yeah, just for the Auslan, we might just everybody remember that a little bit. All right, judges.
Saf, I have a question. I wondered, there's a fair bit of case law from 15, 20 years ago around sterilisation of women with intellectual disabilities against their consent. Could you tell us a little bit about how you engage with that case law and what you've thought about it and the impact that it might have on this case that you're planning?
So for us, with our limited timeframes and ability to consult with people, we did a little bit of research and we came up with some precedent, but we were unable in the timeframe that we're given. So I will take that on notice and I'll pass it over to this question to be answered by maybe Naomi, who's got more experience in law than I do.
Sure.
Naomi, are you here? Otherwise, Bridget, one of the lawyers.
Maybe, are they
able to unmute? Maybe I'll just, So I think on that claim, it would be the whole campaign is based around inclusion and putting disability voices first. So there would be a whole looking back into the history of cases and talking to people who is hopefully still alive to make sure that like their cases are heard, and maybe platforming their stories and putting them and getting, working with other groups, like say, like with my organization, we platform the voices and looking at, people's stories, and also platforming them as a part of the national campaign to say, hey, this is what happened in the past. Why is it still happening? And when we've got this precedent 20 years ago, how far have we come? And then, getting more lawyers involved to be like, what are the gaps? Why the gaps exist between anti-discrimination legislation? What are the gaps between human rights and our obligations, and where the legislation currently is? So it would be very much about highlighting the gaps and how much we're failing as a country to protect the rights of women with disability in this context, specifically women with physical disabilities and intellectual disabilities who are not considered when giving fully informed and free consent.
Thank you.
Does that answer your question?
Yes. Yes, it's very good.
It was hard.
You did great. Unless there's another quick question from a judge, we're going to have to move to the next team. Was there another question, judges, or we'll just move on? All right, we'll move on. Thank you so much, Team 3. Well done.
Thank you.
And now we'll go to Team 4, Education and Children. And I believe it's Clara is going to be the spokesperson.
Yes, that's right.
Excellent. So when you're ready, go. And when you hear a bell, that means you got 30 seconds.
Yep, I'm ready.
Excellent.
Thank you. Our question was focused on delivering inclusion and equity in education for children with disabilities so that no children is left behind. The problem that we identified within that is the need to address segregation in schools, and that many children with disabilities and their families feel as though they are forced from mainstream schooling into segregated settings. These settings do not meet the needs and do not therefore represent, in our view, reasonable adjustments. All children have a right to quality education. Discrimination in education on the basis of disability is unlawful under the Disability Discrimination Act, including subjecting a child to any other detriments on that basis of the student's disability. Our approach was informed by the perspective of advocacy bodies and research, who have identified that there is no strong evidence to support the benefit of segregated education. Importantly, we acknowledge, as one researcher, Dr. Robert Jackson, mentioned in one of his research on inclusion or segregation for children with an intellectual impairment. He mentioned that it is not logical to use poor inclusion practices as a scientific rationale for its abandonment. The issue is that the school have to do better, and in particular, the need to protect the most vulnerable. We want to challenge education systems to provide a much better baseline standard of inclusive education for children with disabilities and their families, and to make sure that the experience in education setting is positive and provides an opportunity for all children to thrive. We also want to reframe conversation about special needs in a way the positions responsibilities in education system and upholds the obligation of the state to ensure all children enjoy a quality education. Our legal strategy targets the Australian Human Rights Commission in the first instance, raising discrimination claims and challenging education system to do better. We have identified 2 groups to reach out to and support to raise these claims. The first one is children and families who are funneled in segregated schooling despite their wishes for mainstream schooling, and exploring equality in funding, assessing including traveling distance, local social connections. And another point is children with disability who are subject to restricted practices, suspension, and exclusion, individually or collectively, within the mainstream system. This advocacy would include greater policy clarity on standards for inclusion education for children and families with disability, and establishing clearer mechanism for oversight, which will bring with it improved pathway for parents to seek help. We also want to improve teaching training to include mandatory inclusive education modules as part of including the baseline capacity of schools. Penalty may be applied if not followed, such as suspension or fines. That's the legal perspective. While we are targeting human rights organizations such as Human Rights Commission and relevant independent commissioners in various jurisdictions, education system, and the community at large, we are particularly interested in engaging children and young people. We were inspired by campaigns about discrimination in Canada that have been effective in child-led advocacy, centered on values of fairness and inclusion. We see this as a key part of driving both immediate and long-term social change. So to conclude, ultimately, we want to change how society think about education. It is more than academic achievements or preparing children for employment, but also in shaping our future society. By improving trainings, awareness, engaging children in particular, we want to shape a more inclusive future. That's my pitch. Thank you.
Thank you so much. Well done.
Thanks.
I'll hand over to the judges. Are there any questions for this team?
It's Graham. I have a question. There have been many complaints already lodged in federal and state human rights systems. How are your complaints going to be different so that they're more likely to be successful than the ones that have already been lodged and been through the federal courts? Yeah, so we thought about giving more channels to reflect the complaints in a more direct basis. And sometimes, to be honest, with the legal system, it could take a lot of time, and also the cost could be high as well. So that's something that we want to work on. One of the things is giving more subsidy to facilitate a faster reflection of the problem on the complaint. But I think in general, helping the general awareness of people actually having the right to complain, that could also be a part of it, because a lot of people being bullied at school, they actually don't even know they have a right to speak up.
This is Natalie. I have a question, if it's okay, with leave of the other judges. Clara, you're absolutely right. Research tells us that people with disabilities and their families often do not know their rights to be treated equally in education. I couldn't quite follow from your pitch how existing legal protections fit within your proposed way forward. Are you suggesting that the current anti-discrimination laws at a state and Commonwealth level are sufficient to protect students with disabilities in the future that you're dreaming of?
Thanks for the question, Natalie. I think the law is very clear about not discriminating, try to eliminate the discrimination actions in school. But I think the most difficult part is the practice and reality. Like, a lot of people don't go through that channel. That's the hard part. And that's why we are thinking a lot of ways to actually facilitate that, including the teachers should be better educated, and including educating the teachers about inclusion, and educate them about children with special needs, because we all deserve education, but people's circumstances are different. It is hard to fit all into one box. So there's so many aspects that we try to work on. It can't be only legal. It has to all work together to raise awareness. That's why we also want to have campaign, but I guess 3 minutes would be a little bit too short to include everything. But yeah.
Thank you so much. Thanks for the question, judges. There's some pretty tough questions there. You've done really well.
Thank you.
And it's a big topic, and you've done very well. So thank you so much, Team 4. I think we'll keep rolling because we're just a few minutes behind, which is not too bad. We've got a little bit of a buffer, but we're going to go to the Team 5. This is about housing, and I believe we've got Hayley, who's the spokesperson for Team 5. Hi, Hayley. So hello. When you're ready, go for it, and you'll hear a little bell from Katie to tell you that you've got 30 seconds to wrap it up. Thanks a lot.
Okay, thank you. Hello, welcome from Warramai country. Okay, so we're doing housing. Okay, Australia's tenancy laws, especially around grounds for eviction, are amongst the weakest in the world, being one of the only Western countries to allow no grounds eviction notices. No grounds evictions provide a loophole for dodgy landlords to avoid their responsibilities or put profits ahead of the well-being of their tenants. Due to no ground eviction rule, people with disability are at risk and open to discrimination within the rental market. People with disabilities are 2.5 times more likely to receive a no grounds eviction notice, and 16% of all renters with a disability have received a no grounds eviction notice within their lifetime. Group 5 is looking to reform the law and follow Tasmania and Victoria's lead to abolish the no grounds eviction notice policy within New South Wales. This will ensure people with a disability have security of tenure, dignity, and freedom to be themselves within their own homes. So our strategy. In order to reform the law, we will need to get a bill passed. We will start by engaging the disability community and co-designing a campaign. We will work with advocacy groups, disability persons organisations, disability service providers to design and lead the campaign. We will use these partnerships to identify key storytellers that would share their stories for our campaign. We will do our best to use people that will engage a large cross-section of the population. We will launch our campaign on social media, using our partners as a platform to raise awareness of the issues and engage platforms such as grassroots forums to find people to be part of our campaign. When we have our storytellers, we will then use our DPO partners to help people make submissions to the Royal Commission. Once we have a level of media awareness for our campaign, we will then send fake no grounds eviction notices to the homes of all state MPs. We will use QR codes at the bottom of these eviction notices to link them directly to stories reported by people with a disability who have been evicted using the no grounds law. Our aim is to create a sense of empathy for people in this position. We will also alert the media so they can cover the story. We will engage media agencies such as the Media Centre for International Justice to help us engage shows like Q&A, The Drum, The Project, and Four Corners. From there, we will partner with other cross-sectional groups that will also benefit from this law change, such as Homelessness New South Wales, Older Women's Housing Homelessness Group, Red Fern Legal Centre, and Shelter New South Wales, all people that have put their support for the abolishment of this law. We will work together to unite and expand upon our campaign and engage a wide range of people to unite the campaign to make the awareness of this unjust law. We will launch an online petition following on from our campaign that all our cross-sectional groups and partners could share across different media platforms. We will focus our campaign on local MPs, particularly those with marginal seats, and state ministers such as Alistair Henske, the Minister of Family, Communities and Disability Services, and encourage them to raise the bill.
Time's
We
up.
would like to create enough land swell and controversy on this on the injustice of this unfair law within an election year. We'll piggyback off Labor's stance against the law and push to make this an election promise on both sides.
All right, we'll give you an extra few seconds there.
Sorry.
Well, that's okay. We got a saving on one of the earlier ones, so you could carry it across. Thank you so much. That was great. Well done, Team 5. Some innovative ideas there. I'm sure the judges have got a couple of questions. Any judges want to say something? Nothing from the judges?
Hayley, did you consider, sorry, Hayley, did you consider litigation in relation to one of these inappropriate eviction notices?
Sorry, say that again. I just had my daughter talking to me at the
That's
same
all right.
time.
That's all right. I just wondered whether you'd considered litigation in relation to one of these unlawful or inappropriate eviction notices.
Yeah, we did look at that. We looked at there was grounds. We saw some people in Tasmania. Oh, look, I might let Marley talk to that because she was looking at the litigation cases for that. Marley, are you there?
Hello. Yes, I'm here.
Did you? Yes. We're talking about whether we considered litigation for this, and I know that you looked up a case for a man that was given an unjust eviction.
Sorry, yes, hello. Yeah, so we looked up a case in regards to a man with intellectual disabilities living in Tasmania, and he had been supported by individual advocacy services as well as I think the tenants union to launch a case against, he had his fixed term lease not renewed. And I think it was the challenge was under disability discrimination law. And it was successful. So we did think about litigation, but yeah, I guess that wasn't the main prong of the campaign, just because, yeah, the number of people who are being served no grounds evictions right now, yes, is quite high.
Thank you. Thanks for the answer. Thanks for the question, Judge. We're going to move on now. I'm going to hand over to Ariane, who's going to MC the next 5 teams. Ariane?
Yeah, thank you, Steve. And here we have Jessica ready to go from Team 6, and Team 6 looked at policing and incarceration. So we'll just, the same way, 3 minutes, bill at 2:30. So over to you, Jessica. Thank you. Sorry, Jessica, we can't hear you.
On the mute button, there's a little arrow up. Click on that.
Yeah. Can you hear me now?
Oh, there you go.
Oh, okay, great.
All right.
Sorry.
That's fine.
All right. Let me take it away. People living with disabilities often face adversity when navigating the criminal justice system, resulting in a cycle of incarceration. Misunderstanding and a lack of compassion is often the root problem that leads to forceful intervention by the police and corrective services. Our team's pitch is to focus on diversion from the criminal justice system and to increase intervention from appropriate social services. Our vision is to establish a new branch of 000 that will respond to calls involving people living with disability. This branch will operate similar to fire, ambulance, and police services. Members of the public can call in and request a social service responder to attend a call. Trained professionals can then be dispatched to de-escalate the issue and can link the person living with a disability to other specialised services for ongoing support. For example, if they were responding to a call involving an Indigenous person, they could link that person with an Indigenous disability service. In addition to calling, the service could be available on apps like the Service New South Wales app, so that it is easy to use and accessible. The app could also have pre-filled information on the individual to help streamline the process. Further, this service could be accessible through personal alarms, as these alarms already have the capability to contact 000.
For this idea to be successful, further training is needed for other emergency services to identify when their social service colleagues should be called upon. Further, a public awareness campaign is needed to publicise this social support service. For example, a movement similar to the National Domestic Violence Campaign would be a good starting point. And of course, this campaign should be led by people with a lived experience. The biggest setback to this idea is the cost of setting up a new branch of emergency services. No doubt this would be an expensive service. However, it should be noted that currently the cost of putting a person behind bars in Australia is approximately $109,000 a year. This idea, although expensive, will reduce these costs by diverting people away from our prison system. Further, although this idea is designed to assist people living with disabilities, it has a range of other applications. Social service responders can assist with calls from schools, from people experiencing mental health crises, or from people who may be drug or alcohol affected. To effect this change, our group proposes lobbying state ministers and policymakers by writing letters and serving written submissions. We could also run a test case based on R and Inwood 1973, explaining that Australia's common law has recognised that special procedures may be required when arresting a person with a disability. This case could be used to explain why we need a dedicated social service responder branch of emergency services. We believe this pitch, although ambitious, will make a positive impact on the way people living with disability seek support and help in a time of crisis. We believe that diverting these issues away from police will allow people living with a disability to seek the support they need, and will also have wider applications that will be beneficial for the Australian community. Thank you.
Thank you so much, Jessica and Team 6. That's a really interesting idea. I'll hand over now to our judges. Do we have some questions for Team 6? No question.
I do, sorry, it's Natalie. I just wanted to clarify whether the new emergency services branch only assisted people that were sort of at the arrest or emergency stage and not those that are incarcerated, or have I slightly misunderstood?
So the idea is that it would be similar. So instead of calling, a police officer, if you saw someone in distress, that social support would go out and kind of try and divert the person from the prison system at the start. So it would be similar to calling up, an ambulance or fire service. They would be the first point of contact to hopefully de-escalate the situation, with the idea that the police is the absolute last resort.
Okay, so it is just policing and not incarceration.
No, yeah. We want to try and attack it before it gets to that stage.
Got it. Thank you.
Thanks, Natalie. Thanks, Jess. That makes sense. Do we have one last question from one of our judges? Are we ready to move on? I think so. Thank you so much, Jess and Team 6. Well done.
You.
Now I'd like to invite up the representative from Team 7. In Team 7, we're looking at healthcare, disability support and aged care as well.
Me, Francis.
Oh, hello, Francis.
Hello. Hello, everybody. Yes, we're taking on question 2, and I will begin. So we'll be looking at disability support services, the right to autonomy, personal integrity and legal capacity regarding access to representation and advocacy in matters regarding the NDIS, in particular AAT and external appeals. People with disability have the right to full citizenship in the community. People with disability have the right to representation when taking NDIS matters to the AAT, as per Article 12 of the CRPD, Equality Before the Law. Currently, the system is a David and Goliath battle that creates an inequitable power imbalance that appears to favour the agency. It should be noted that 75% of people with disability who take matters to the AAT regarding NDIS appeals are unrepresented and face NDIA agency lawyers. It should also be noted that the NDIA spent $28.9 million in legal representation on such matters over the 2019-2020 financial year. People with disability have the right to equality before the law and an equal playing field when facing a large agency such as the NDIS. It should also be noted that Section 17A of the NDIS legislation states that people with disability will be supported so that their choice and control is maintained. What we propose is that plans have an optional component to allow participants to seek representation, that is legal representation, when dealing with the agency. Presently, the situation is inequitable. Therefore, we propose a legal strategy. We propose to begin proceedings with the AAT and ask the AAT to ask the NDIA to make provision for a participant to have representation, that is, to pay for their legal representation. Should this be refused, we intend to take this matter further to the federal court. There are matters, I am aware, in the federal court at the moment. We will also use the complaints mechanism of the Commonwealth Ombudsman, because the NDIS now has to report annually to the Commonwealth Ombudsman. We will also have an advocacy campaign. We will engage the disability sector vigorously and use social media tactics to our full extent. We will use media releases, blogs and vlogs, and we will have people with disability telling their stories and experiences of having to deal with the AAT, or rather having to deal with the NDIS at the AAT. We do know that this strategy would be rather expensive and that funding would be required. We would be requesting pro bono services. We would also be looking at pooling our resources from the DPO DRO sector and from people with a philanthropic nature. Access to the NDIS is a human right and is an obligation under the CRPD. Australia committed to the NDIS as part of the CRPD implementation. We committed to it. Further, the NDIS Act states that as an objective, the NDIS, that as an objective of the legislation, it is to protect and prevent people with disability from experiencing harm arising from poor quality and unsafe support and services. We would argue that currently under the situation, people are experiencing harm in their experiences of dealing with the NDIA at the AAT. The current situation is an unfair fight. It is an unequal playing field. It breaches several points of the actual NDIS Act and also contravenes the CRPD Article 12, equality before the law. People with disability are citizens first and foremost and have the right to representation in any legal setting, including the NDIS. And thank you to my dogs in the background.
Thank you so much, Frances. That was right on time. And thank you for your puppies for making an appearance too. Do we have a question from the judges, please?
I have so many questions, but I'll try and limit it to one so that I don't get beaten up by my fellow judges afterwards. Which to ask you, Frances, that was really comprehensive. I think the one that I'll go with, and hopefully one of the other judges will pick up on any other questions I have, is why not seek costs from the NDIA for legal representation? Why try and put it through what I assume you mean to be a participant's plan, given that's the only way that the agency can sort of provide money to participants? Why not just seek cost orders?
So why not simply request the NDIA to pay rather than having it out of a plan? Is that what you're asking?
Yeah, so at the moment, there's already provision within the AAT Act to allow costs to be awarded to a party. Why would participants not start to systematically seek cost orders against the agency?
Oh, that's a very good point. I wasn't aware of that particular provision. I have no answer to that other than the fact that we haven't had any of our participants access that particular option.
I don't think it's very popular. I don't mean to engage in a conversation. I'm sorry, everyone, but it's traditionally a no-cost jurisdiction, of course. But there is provision in all courts and jurisdictions for cost to be awarded.
Oh, and indeed, you know, through the NDIS appeals funding, participants can access legal aid, but it's only a consult. There's nobody necessarily there with you when you actually go up into the tribunal. So that, you know, you might have an advocate, you might not. As I said, 75% of people don't have anybody.
No, you're quite right. The current approach is absolutely inadequate. That's absolutely right. Anyway, sorry, I'll be quiet.
No, thank you.
It's really good.
And Francis, now do we have a really super quick question from another judge before we move on? Are we okay? Yeah, all right. Well, thank you so much, Francis. That was very well delivered and well thought through presentation. We're now going to have a representative from Team 8 deliver their pitch, and their topic was on the rights and law area. So,
hi, it's Sarah Hubolt here.
Hello, Sarah. Thank you.
Yeah, no worries. I'll be speaking with my camera off because it is better for my access. I'm in Southeast Melbourne on the land of the Boonwurrung people, and I'm in Team 8 with some incredible teammates, so thank you to all. We had the topic also of involuntary sterilisation, and so the context, just to recap, and thanks for another team having the same topic, just to recap that involuntary sterilisation is still a global phenomenon. It's something that is occurring everywhere in secret. We've had the Marion case in Australia, which has suggested that it's illegal, except it's allowed if it's a therapeutic reason. We know that under the CRPD, the Australian government has reservations around involuntary sterilisation. We also know that there's informal WhatsApp group of parents asking where the best place is to get their children involuntarily sterilised, and some of that is going overseas to places like Thailand to get it done under false pretenses of other medical procedures. With this context, we are aiming to create increased common awareness amongst the general public that involuntary sterilisation is a thing, it exists, it's still happening. We'd like to shift the Australian government perspective to remove the reservation of involuntary sterilisation so that all parts of the UN CRPD are supported. And we'd like to prevent the practice from happening in the first place. And in doing that, we'd like to reshift the messaging around, because often we're talking about the rights of women and girls. We'd like to actually look at the situation and suggest that to talk about the benefits of non-sterilisation for the family. So, for example, it could increase family cohesion, or there could be economic benefits for not having children and young adults sterilised. So, our suggestion, our pitch is around creating a feature film. The feature film is called The Last Resort, and that's a take on going to Thailand and going to an amazing resort and then getting this medical procedure done. It's also a take on that sterilisation, compulsory involuntary sterilisation, or sterilisation should be the last resort under all costs under the law. So the reason for making this a feature film is to socialise the concepts in the general public and have global traction because it is a global issue. So we're looking at a film that includes authentic casting. We'd like to cast Jamie Brewer, who is an incredible actress from American Horror Story who has Down syndrome. And we would like to suggest that the timing is quite right for a feature film. Currently, there's a film in production around the Buck versus Bill case in America from 1923, and Dakota Johnson is playing the woman who gets sterilised. So that's quite concerning from an authentic casting point of view, but it also means that the conversation is going to become in the mainstream very quickly once that film is in release and circulation. So the time is incredibly right to pitch a film that has a more authentic voice and more complex issues raised for a current situation, and it joins the groundswell that we know is inevitably coming. We'd like the film to have an Australian story. For example, imagine a young woman sitting in her bedroom reading easy read material on contraception choices. So we'd like this film to showcase all of the nuances and life experiences that might be around this particular topic. We also acknowledge that in Slovakia at the moment there are compensation cases for women and girls who have been previously involuntarily sterilised, and we'd like that to feature within the narrative of the film. This film could be fictional, it could be documentary, that's unclear at the moment, so that's part of creative development of filmmaking. We also have precedents in this space in terms of how powerful a film can be in terms of groundswell. For example, Sarah Barton's Defiant Lives, which toured around, is used in educational institutions and was screened at the UN. Bus Stop Films is doing incredible stuff, and we all know about Crip Camp and the power of the conversation that that has brought. At the moment, we also have target responses and quotas from the Australian film industry, and so the funding is likely to happen and the success is high. So it's legit, possible, and exciting. The risk in terms of making a feature film, one of the pathways could be that you make a short film first and tour it to places like Karlovy, which is in Croatia, which is very close to Slovakia. So you could get overseas interest before Australia picks up on it, but, you know, we'll see. So in addition to making the film, which takes 2 to 3 years generally to make, so we've got time in terms of building up other strategies. So we're also looking at litigation potential to find a young woman with disability who has experienced involuntary sterilisation with parental consent. And instead of focusing on the parent, we'd like to focus on the medical profession or a particular hospital. If that can lead to a class action, great, but we'd like to really look at a civil case for assault in terms of the medical profession. In terms of advocacy, there's a lot that can be done and that can increase over time with the timing of the film's make and release. So student debates on the meaning of what is therapeutic, for example, in secondary and tertiary education, social media stories of economic comparisons of contraceptions, and really looking at the costs of sterilisation and kind of going, well, that's not a good deal. So, you know, there are so many other ways. So shifting the landscape, yes, it's a violation of human rights and it's also economically expensive. We'd like to join up our campaign with the Me Too movement to encourage the wider women's movement to understand the experience of our women and girls with disability, and that it does fall under the Me Too movement in terms of violence against us. So women, we'd also like to look at advances in science and technology and menstruation, for example, and really look at all the nuances that create the experience of someone who might be going through involuntary sterilisation. And really also looking at a disability-led approach, nothing about us without us, and also being very sensitive to providing the space and place for women to tell their stories in hindsight, because it is such a hard, it's a hard space to be in, you know. So we'd like to also influence the family courts, because what we found, and other courts that have a very high approval rate of supporting involuntary sterilizations, there is research out there that says that 95% of cases that go before the family court are approved. So we'd like to do some influencing in terms of the legal profession, and that will be about relationship building, writing letters, and strategic campaign over the course of, and potentially once the film has been released. So the timing will be important. In terms of the election cycle, writing letters to MPs, it might not be this time round, but it might be next time round once we build up the groundswell. So looking at the timing of targeting MPs in this space, and also the timing of the Disability Royal Commission fits in with our filmmaking timing as well, because as the reports and recommendations get released from the DRC will be when we launch our film. So the activities of the wider disability advocacy and women and girls with disabilities, so specifically widows, incredible efforts can be timed well in terms of the release of DRC findings as well as our film.
Thank you, Sarah. I just need to wrap up now, please.
Yeah, no problem. We also had actions around the AMA, and we also acknowledged our opponents and what the messagings and the reframes might be. So thank you for listening to our pitch.
Thank you, Sarah, and thank you so much to Team 8 for all of your work. Just a quick question from the judges, if there is one.
Oh my gosh, I have another one. Sarah, you mentioned the family court and their prevalence in ordering involuntary sterilisation. Okay.
I'm so sorry, that was an error from me.
Oh, that's okay. Oh my gosh, thank gosh that was not me. Excellent.
Or me.
I thought I had disrupted the whole system then. Oh my gosh.
No, that was just me.
Okay. So Sarah, did you turn your mind to guardianship laws? So we often know that guardians of adults and adults with disabilities will also engage in involuntary sterilisation procedures.
Yes, we did. And we also talked about we talked a lot about litigation and to see whether it was our first foot. We wondered if that was our thing that we pitched. And we really investigated what a litigation guardian. I'm not the best person to answer this question, so fellow team, please jump in a second. But we did talk about guardianship and who would represent and what that would be like. And we do acknowledge and understand that any age is a woman or is from any age has the potential to be at risk of involuntary sterilisation. Team, I'm going to throw it over to any of my team members.
And what I do, Sarah, I should clarify, I don't mean a litigation guardian, I mean guardianship and administration laws around the states and territories.
Yeah, I guess we didn't look at it specifically, the guardianship laws, but I do note that in New South Wales, the rate of approval of sterilisation is much lower. It's about 40% versus the family court's 95%. So it is a big difference. And we did discuss as well the importance of supported decision making. So not purely substitute decision making that parents or a guardian are purely substitute decision makers, but the importance of having to the extent possible, any input from the person who is looking at undergoing that procedure, and sort of I guess more of a community discussion model rather than a judge sort of making a pronouncement from on high.
Yeah, thank you, Karina, I think that was, and thank you, Sarah and Natalie, for your question. We are going to have to move on now because we are, yes, we are on a tight time frame, but thank you very much, everybody. And now we'll welcome Sophie from Team 9. Take it away, Sophie.
Thank you, Ariane. I would first like to acknowledge that I'm speaking to you from the unceded sovereign lands of the Gadigal people, and I would like to pay my respects to elders past and present. As a person with disabilities, discrimination in education is an issue that is particularly close to my heart. While there are numerous issues with the education system in relation to inclusion and equity, we have decided to focus on segregated settings in education. The Australian Coalition of Inclusive Education's definition of segregation in education states that segregation occurs when the education of students with disabilities is provided in separate environments designed or used to respond to a particular or various impairments in isolation from students without disabilities. We believe that segregated settings are discriminatory, and we recognise that First Nations children and young people are especially impacted by segregation. Our vision is that no child is left behind, specifically in relation to the issue that we've chosen to focus on. Our vision is that a single universally accessible system of quality and inclusive education for all children and young people, which is also culturally inclusive and safe. Our goals and objectives are that legislative changes to provide for positive right to inclusive education, and also improving the Disability Discrimination Act to ensure it works more effectively. 2 would be policy reform and building into policy the empowerment of students with disabilities and the ability for them to input how they are best supported. 3, to educate education providers and the community as to the negative impacts and discriminatory nature of segregated education. And 4, to move away from paternalism and to recognise the autonomy of persons with a disability. Our legal strategy would focus on First Nations students. We would seek to bring a representative action in partnership with and with the direction of from First Nations communities and First Nations and disability peak organisations. A class action was a strategic decision given the current case law landscape. We considered the most appropriate jurisdiction for bringing such an action, such as Victoria, to utilise the Charter of Human Rights, or at a federal level where change and impact can be more broad. But we decided this would ultimately be a discussion with the plaintiffs and partner organisations. We also discussed that the outcome of the litigation isn't necessarily the end goal. It's more looking to what the litigation can change, such as the incremental changes like in the land rights cases consistently that were unsuccessful until Mabo. In terms of advocacy, we would partner with First Nations communities, First Nations disability organisations, and other peak disability organisations. We would work on a broad campaign, all in partnership with those partner communities and organisations, which would include utilising social media to develop a strategic communication strategy from students with a disability in segregated settings, particularly from First Nations communities, to tell their stories through film or some other mechanism. And that was inspired by the Raise the Age campaign. And we also would look to highlight good practice, so shining a light on the positives that this change will give rise to, such as better outcomes for all children and young people, because students with a disability would have better access to education, which is good for all students to learn and understand the importance of inclusiveness. And third, we would engage with schools and the various departments of education to get schools the proper supports and funding to provide inclusive education for all students. Thank you so much.
Thank you so much, Sophie. Well done. Can I hand over to one of our judges? Have a question to get us started?
Yeah, I have a question.
Please,
you talked about as your legal strategy changes to the DDA. What changes did you envisage to achieve the aim of inclusive education?
A very honest answer is that we didn't get, unfortunately, to look at that in depth. I would love to be able to point to specific sections of that legislation that we would like to change, but we just didn't get the time. But it came about because of a discussion about how the current legislation is not accessible enough for people with disabilities to utilise the complaints.
Can I have a second question, Natalie, or I'll let you make a call?
No, absolutely. I think I've had more than my fair share, and I think that's right.
Can I ask then, where's the where do you propose to take the litigation, the class action?
Sorry, could you?
Well, you talked about a class. You talked about
Yes.
a class action.
Mm.
So what's the jurisdiction that you're taking the class action in?
Oh, thank you. Okay, so we discussed both a couple of options, somewhere like in the state of Victoria, where we could utilise the Charter of Human Rights, but then it has its limitations because the outcome would be, the name has escaped me, but essentially a direction rather than the ability to get any sort of damages for the litigants.
But is it a discrimination action?
Oh, sorry.
That was my question. I'm sorry I didn't ask it.
Sorry. Sorry, no, sorry, I misunderstood. It would be an action probably we envisaged probably brought by students who with a disability who have been put in perhaps a separate school, but we didn't really get the time to expand on that in detail.
Thank you.
Thanks, Graham, for the questions, and thank you, Sophie and Team 9. Well done. And last, but certainly not least, we have Nikita from Team 10, and their question again was around the housing. So over to you, Nikita. Thank you.
Thank you. So our challenge was housing and how we can ensure people with a disability have access to suitable housing so they can live with dignity, freedom, and be connected to supports, friends, and family. In terms of what needs to change, we think we need more accessible housing for people with all types of disabilities, which is connected to their community, family, friends, and accessible services. This means that we don't want housing which is on the outskirts of the city, away from employment opportunities, away from the services that they need, and from public transport. We want housing where people can live independently if they want to, noting that at the moment, there's a lot of housing for people with disabilities in group housing, but there are limited options for people who want to live alone. In terms of this sort of strategy, I guess, and the key objective, what we want to do is to make the most of low vacancy rates for central units and apartments across Australian cities. We think there's an opportunity for collaboration between the government and building developers and building owners to use vacant buildings, vacant apartments and units, and provide them as residences for people with a disability. We think a benefit of this approach is that it's cheaper than building new houses for people with disabilities. In terms of the vacancy rates in the cities, there's about an 8.3% vacancy rate in Sydney and a 6.2% vacancy rate in Melbourne. The focus on this would be on advocacy and public-private partnership to get people to work together to come to like a win-win situation. We would approach this by firstly asking developers to build housing which is accessible to people with a disability in the first place, and do this by providing financial incentives to do this, like government rebates like is done with SDA housing, and ensure building codes and the National Disability Standards 2010 meet the requirements and needs of people with a disability. Where an owner or developer has a vacant unit or apartment, they then advertise it on a website specifically for people with a disability who are looking for a residence where they can live independently. And the owner and the developer would then set a rate, which would be a discounted rate to what they would ordinarily charge. And in terms of getting them on board to do this, we think it will be a commercial and sort of reputational strategy for them to say that they're a signatory to this scheme, which supports people with a disability to access affordable housing and improves them in terms of improving the community perception of them. A person with a disability would then occupy the premises and pay a certain amount, and the government might subsidise some too. One of the challenges for this would perhaps be public backlash in terms of some people might think, well, we don't want certain people living in our building because it might devalue our property in the same way that people might say those things about public housing. But this is where we think the legal strategy would come into it. If, for example, a body corporate tried to introduce a rule that said that a person with a disability couldn't live there, we think there'd be strong grounds to challenge this on discrimination grounds, because it would be unlawful discrimination for there to be a rule in place which prevents people with a disability from living in the building. I think I'm probably close to 3 minutes.
You have to wrap it up. Yeah, thanks, Peter.
Thanks.
You want to wrap it up quickly, or?
Just one other thing I was going to add is that we think this will create a positive cycle for change, because people with a disability will then be living in the city with greater access to transport and the networks that they need.
Great. Thank you so much, Nikita. And judges, do you have a question for Nikita or Group 10, please?
I do. Nikita, who is responsible for this scheme? Is it government or is it private sector? Who is it?
Yeah, it would primarily be the government who would start it off, and then it would sort of be, I guess, a partnership with the private sector to get it up and running.
I have a follow-up question. With the current pandemic, there's increased speculation that apartment living will not be the way forward with respect to ventilation and other issues. Do you think it's a good idea to set up the future of housing for people with disabilities who are, for the most part, vulnerable to COVID and other pandemics, a good idea to put them in apartment living?
Hadn't thought about that one, but I think that would perhaps come into maybe when you're at that starting point of building these properties. that would be maybe one of the things to consider in terms of ensuring proper ventilation of these buildings to account for those situations.
Thanks, Nikita, and thank you very much, Natalie.
Excellent. I think we've come to the end of all the teams. Is that right, Ariane?
Yes, we have. And thank you all so much.
That's been amazing. I just want to say, and on behalf of the NJP, so great work, teams. I know you worked really hard today and you've been put under pressure, time pressure, and then judge pressure. Really great questions from the judges. That's what they're there to do, but I'm glad I wasn't answering them because my mind was swimming, just absorbing all that wonderful information. I think there's been some fantastic, impressive and creative pitches and some really great solutions, some of which are groundbreaking and some of which are really push the boundaries. So what we're going to be doing now is the judges are going to have the difficult task of deliberating. They're going to be moved into their own private area for about for 15 minutes. And then they will come back and join us with their, I guess, their winning pitch. And in the meantime, whilst they're being moved out and for that 15 minutes, Ariane and I are going to take you through a little bit of behind the scenes information. So I'll get the judges somehow to be magically moved to the other area. But really, thanks. Well done, everyone. Lots of emojis for the teams. Give yourself good emojis, please. Only good ones. And there was a dog that contributed, which was great too. So animal rights represented as well, which was great. Excellent. Loving all the love hearts. Brilliant. Okay, so if the judges are gone, somebody let me know they are.
I think they are, yeah.
Okay, because all right, what do we want to say about those nasty judges? They were so tough. That was, look, it's an important part of the process, but wow. Get used to it if you're a young advocate. That's what's going to happen when you get out there to do something. So look, we've got some slides and a bit of a discussion about where we came from and why we ended up where we were. So the next slide, please, the graphic. I think it's, yeah.
You can just keep going.
Sorry, just bear with me a moment.
That's okay. I can wait or I can talk. So look, you're probably wondering, some of you may or may not know this. There'll be people who are coming in to watch today who may not know exactly kind of where the idea for the law hack came from. So really it actually was came out of our fearless CEO, George Newhouse, who's never short of an idea of what we can at the NJP can do to help change the law in a positive way. He thought that it would be a really good idea for us to host an annual event that wasn't just a typical gala or a dinner with speakers. He envisaged something that would celebrate the magic that happens when you bring innovation and social justice and collaboration together. And that's what the law hack really is. It's a perfect match to the National Justice Project's spirit and commitment to strategic legal action, fearless advocacy, social justice education, and cross-sectorial partnerships. So there's a lovely little graphic that kind of shows you what happened and leading up to getting here today and everything that's gone on. And if you have a look at that, it's a great representation. The Disability Royal Commission was underway, and that signalled that the status quo had to change. Conversations were had with wonderful compadres, Rob Silverstein, Katja Malakias, and our community partners and courageous NJP clients, indicated there were significant limitations to current disability discrimination laws in Australia as a starting point. And so it was decided that disability justice should be the theme of the first law hack. There will be more law hacks in other areas of law in the future, which we are excited to be able to do. So we all know that impact is magnified through collaboration. So they're saying is, if you want to go far, go together. And so we knew we couldn't do this alone. So I'll hand over to Ariane.
Thanks, Steve.
Next
That's okay. I guess I just wanted to talk through, some of the intentions that we had for this. And I think there are a few, and there are some really powerful ones that I think it's really important to bear in mind as we, wrap up this epic day. So one of them was, of course, to showcase the important work of the organisations and advocates on the ground doing the work. We all know how important that is. We really wanted to build multidisciplinary teams of participants that recognised that strategic action can't be done in isolation with lawyers. It's just not good enough. It doesn't touch the areas that we need to. So it was really about identifying the different skill sets and bringing them together as the experts. So people living with disability, their families and their carers and communities can be the drivers. When we started to, speak with people, the participants, it was really encouraging, the responses we were receiving. Many people in this room today have been directly affected by the issues that the teams were exploring today. And we are truly, truly humbled for everyone's courage and willingness to participate and share your stories along the way to make sure that we got this event and the challenge statements to where they needed to go. We really wanted to deliver an event that enabled us to give back to the community. So all of these strategies and solutions and discussions that we've been having today, they belong to all of us. They belong to the community. And we really, they're open source. We hope that they are picked up by some of the incredible, firms and organisations, both nationally and internationally, and that this is just the beginning, I suppose. We know that the Australian legal sector does an incredible amount of pro bono work to enhance social justice, but we hope that that this law hack and this focus on disability justice will inspire them to prioritise cases of injustice experienced by people with disability. Next slide, please, Jane. I just want to quickly talk about our community partners, because naturally, as soon as this idea was born, we went and spoke with the experts, and we connected with peak advocacy organisations around the country to really float the idea, see what they thought, and seek their guidance. So the response again was really, really encouraging. Overwhelmingly, our community partners were so relieved that it wasn't just going to be another opportunity to talk about the issues, that we were actually going to come together and develop solutions and strategies for change. And I think that focus on actionable solutions really makes the noticeable difference of an event like this that we've had today. So I just want to quickly do a shout out to these amazing community partners that reflected the diversity and the lived experience and the intersectional experiences of people with disability. We really can't thank them all enough. Without our community partners, this event really wouldn't have been possible. And I'm so pleased that all of these organisations are represented here today. So just quickly to shout out to the First Peoples Disability Network Australia, that is the peak organisation for First Nations people with disability, National Ethnic Disability Alliance, which is the national organisation that advocates for the human rights of people with disability, their families, from culturally and linguistically diverse and non-English speaking backgrounds. The Council for Intellectual Disability is a national disability rights organisation led by people with disability. And we had our amazing keynote speaker, Justin Thomas, from the Council for Intellectual Disabilities with us last week. Women with Disabilities Australia, the peak advocacy organisation for female identifying and non-binary people with disabilities. People with Disability Australia is a national disability rights advocacy and representative organisation made up of, led by and governed by people with disability. And Arts Access Australia, who's the national peak body for arts and disability. We worked very closely with these organisations, and we really can't thank you enough for everything that you have contributed and for being here in India. Thank you. Over to Steve. Got to do your mic, Steve.
Yep, it's all right. It's the first time and only time it's happened. Next slide, thanks. We also knew that we couldn't deliver this law hack without philanthropic partners. There was a moment of serendipity, and from one wholehearted conversation with a very special person, we had a champion. As champions tend to go, one brave champion became two, and we're underway. We can't thank our donors enough because they believed in the idea to do something a little bit different that might just change the world for the better. Now, as you all know, convincing 4 amazing sponsors to spend their hard-earned money on social justice during COVID-19 is no easy act. But the Law Hack 2021 disability justice was something they just couldn't pass up, and they knew it could be an opportunity to be real agents of change. So we were very, very fortunate to have Thomson Reuters, Scope Australia, Ring Central, the New South Wales Bar Association, the Information Access Group, and King and Wood Mallisons in our inner circle for this special event. I'd like to share a special shout out to the King and Wood Mallisons team for working tirelessly with us to support the event today. You've been amazing. Thanks, Jane and Marlon. I hope I got their names right. So next slide, please. We would also like to thank and acknowledge our incredible research and input from the Monash University Law Clinic students who work tirelessly alongside the National Justice Project staff and volunteers to provide the teams with research to inform the development of their ideas. I actually am a supervisor of that clinical program, and I can attest the students were very, very inspired by their involvement. And I can attest that that the hack packs that have been produced were definitely formed with the students. And so it's fantastic to have them involved. Seeing their passion alight and their knowledge and dedication to disability justice through their contributions was really a pleasure to witness. I'd also like to thank the UTS Disability Network, who have provided invaluable research and advice along the way. And I'd like to extend our heartfelt gratitude to our event partners, including the absolutely amazing Liz Clark from Liz Clark Events, Studio A Artists team, and Considered Co, who packaged up delicious, consciously procured care packs for our Law Hack participants. Sorry, I just turned my phone to silent, which I should have done beforehand. So next slide, and Ariane.
Thanks, Steve. Yeah, I just thought quickly just to, I guess, look back at the challenge statements that each team looked at today. As you would have heard, each team, 2 teams received each challenge statement, and it was a really difficult process to, I guess, reduce down the ideas to 5. But we did that in partnership with many people here today, and I think the teams did an incredible job in highlighting the sort of focus areas under each of these challenge statements. They really all are about reducing discrimination against people with disability and ensuring the realisation of human rights. And I'm sure everyone on this call now is as impressed as we are at the responses from the teams. So as we're showing now on the screen, the first challenge on policing incarceration, there's a incredible artwork by artist Tom Roberts from Studio A. And I guess something that I took away from Tom's interpretation was that, as we all should, we expect, or we would hope that, maybe not expect, we wish that police services could be there to protect the community and the disability community and otherwise. But too often, as we've seen, particularly for people with disability, with intellectual and psychosocial disabilities, that sometimes interacting with police can lead to overrepresentation in the criminal justice system. So we really recognise that that's a really important area that we wanted to explore. So we did hear from some of the teams around the training aspect and the police response, and I'm so glad that sort of the teams touched on that, because the reality is that police are not medical professionals and they're not even trauma informed. So to have them to have the teams address that, and hopefully to some really interesting strategies was really a pleasure to see. Next slide, please, Jane. The next challenge was around healthcare, disability support and aged care. And again, you'll see up there an artwork by Victoria Atkinson, and the description from Studio A, and the description is around, reflects, I think, the importance of having supportive healthcare, how important that is, and that every person and particularly people with disability deserve and have the right to adequate healthcare and proper support. Next slide, please. The next challenge was a pretty heavy area. We were looking at violence, involuntary sterilisation and restrictive practices. So naturally, not the best one for our artists to respond to, but I just wanted to highlight that this question really came from conversations with Women with Disabilities Australia and the UTS Disability Network, and I think and people touched on it. I believe Sarah touched on it in her response. The fact that this is a global issue, and that people that you speak to, even conversations I've had since Law Hack, since preparing for Law Hack, people have no idea that these sort of atrocities are still happening. And the reality is that so many people are affected by it, and people seem to think it's a thing of the past. So I'm really pleased that the teams were able to come up with some strategies for that. And yeah, thank you. Next slide, please, Jane. Education and children. We have an artwork here from Megan Pelham, and again, it's reflecting the importance of having a supportive education environment and the value in having an incredible supportive teaching, how important that is for young people. So, and thank you to the teams who addressed that question as well. And the last slide is it's for the housing question, and another one from the amazing artist Tom Roberts, and it is his dream home, his dream group home. And again, talking about feeling safe and just reflecting on how important that is, and how every single person with disability has the right to safe and accessible housing. So that's really all. That's all the challenge statements. And now we might
get
turn off the slides there.
The judges are going to be coming back in a minute. I just thought it might be good. I don't have a slide for it, I don't think, but the judging criteria, I'll just refresh everyone's minds. I've got 1 minute. So the word change, and if you look at the word change, we've gone through the criteria of being courage, humility, achievable, novel, grounded, and evidence. So that was really clever because it actually comes up with the word change. Now, I wasn't responsible for that, and I just noticed that. So whoever did that is very, very clever. So just somebody indicate to me when the judges do come in. But as we talked about at the kickoff, we wanted these pictures to be brave and courageous. We wanted them to show respect, and we wanted them to be clearly actionable and achievable. We wanted them to be original, creative, and innovative. We wanted them to be grounded in the challenge statements and the lived experience. And we wanted there to be evidence where there's research data and evidence of need. And I have to say that all of the pictures so far have really followed those judges' criteria. And I'm sure the judges will reflect that when they get back in here. I'm not sure how far away they are.
They're on their way.
45 seconds, okay.
While they come in, I guess, they're going to make an announcement, but, we're all just so impressed and pleased with everyone's responses. And, I actually can't wait to go back and sort of watch the recording of this and digest all of the amazing ideas that you put forward today. So thank you all so much for all of your hard work.
Absolutely, and we discussed this, I think, before with a smaller group, that There's so many ideas that could come out of this that could be carried forth. It's open source. We're open to anybody running with it, collaborating with us or collaborating with each other. If somebody's very passionate about something that's come out of this, let's talk to each other about it. Let's stay in touch with each other, because we don't know if what could come out of it, and we are hoping for some real change, and I think there will be. So I think I'm seeing judges emerging just as I ran out of things to say. So that's great timing. So when all the judges are in,
welcome back.
Welcome back, judges.
Thank you for having us back.
Yes, there was a bit of.
You were at a crossroads there, Steve. You could have pressed the other button and shut this out.
Well, it was we were wondering if we wanted. No, of course we wanted you back. Everybody's sitting here. There's 100+ people with bated breath, wondering what's going to happen. So I'll hand it over to you to go through what you want to talk about and announce, and then we'll wrap it up from there. Thank you so much.
Thank you very much. I just want to check that Scott is there. Sorry, I just couldn't see him. Okay. So hello everyone. My name is Natalie Wade, and I am the Vice President of Australian Lawyers for Human Rights, and obviously one of your judges today. On behalf of Margarita, Graham, Scott, and Rob, I have the unenviable position to deliver today's outcome. Before I do so, I just wanted to make some general comments from the judges. Now, unlike the many and very high court decisions that you would have read at law school to date, these won't be as voluminous, but I hope they are in part as enlightening. Perhaps not. Who knows? Let's find out. So, coming into this, we were very mindful that it is a law hack, and the legal rights of people with disabilities in Australia, as you have all very rightly pointed out, are a little amiss. One could say that they are oppressed and for the most part are left out of or not considered in the legislative regimes that govern our country. And the judges were somewhat saddened that some of the particular technical parts of legal frameworks and Australian laws were missed by lots of the teams in developing law reform campaigns. So when advancing the rights of people with disabilities in Australia, it is absolutely fundamental that you as campaigners, advocates and lawyers have deep and technical regard to the operation of the law and where reform is required. And we find, in our humble experience, that often your campaign must and can shoot from a ground of law reform. That is, that the law is inadequate to properly protect and promote the rights of people with disabilities in this country. So we just wanted to park that with you as something going forward, that if you ever do have the opportunity to do your bit to advance the rights of people with disabilities in Australia, or if you do participate in a law hack again, we would strongly encourage you to create a better and deeper understanding of the law and legal principles at the outset. So having said all of that, without any further ado, and before my poodle starts barking, I am very proud to let you know that Team 6 is the lucky winner of today, and that is for the Special Responder Emergency Services branch, which will offer a de-escalation point for people with disabilities who would otherwise be arrested or at least have contact with the police and in turn incarcerated. So congratulations, Team 6. Our sincere well done.
Wow. Thank you so much for those wise words and for the constructive critique. It's really, really important that we all hear from you as the experts, and a wonderful choice of pitch. And hopefully it's something that we can take away and work on and turn into something real. But look, I think everybody should be congratulated. It's a tough ask to come out on a day and do this. And we do hear you, judges, in what you said. So, Ariane, do you have any words before I wrap up? And I've got some extra thanks, etc. Anything you want to say to Team 6?
Yeah, congratulations. I think that it was a really interesting and practical response. So well done, and thank you to the judges, and thank you for your comments as well. I guess the teams did have a lot to get through in one day, so I think they did pretty well to get around everything they did. So well done, everybody, and obviously the teams were made up of different skill levels and different experience as well. Some people brand new to the space, so everyone did really, really well. And just thank you from the bottom of our hearts for giving us your time, and I genuinely mean it when I say that I'm so excited to go back and review what happened today. It's been a bit of a whirlwind from our end, but we really just thank you for everything and for your patience with us as we sort of got through this. So thank you all so much.
And thank you so much, judges, and for your for your commitment and for your time. It's very much appreciated, and we'll make sure that we get the pictures collated, and we'll get them out to participants and to the judges, so that people can look at them and talk about it and keep the conversation going. Would Team 6, the spokesperson, want to just say a few words? I'm putting you on the spot. I can't remember. Hang on.
Jess, wasn't it?
Yeah.
Yes. Hi.
Yes. Do you want to? Can we pin Jess, or just if I'm not sure if Jane?
Your acceptance speech, Jess.
I know. So our team was Carolyn, Fraser, and Jim, who I think are all still on the call. So it was definitely a team effort. We were a little bit lost at the beginning of the day, with policing and incarceration being such a major issue, not only with people living with disability, but also intersectionally. So thank you for your feedback, and thank you for selecting us to win. I also just put in the comments as well, in the round robin sessions, Team 7 gave us some really constructive feedback, which helped springboard this idea. So thank you particularly to Francis for your feedback and expertise in this area, which helped guide our final submission. So thank you, everyone, and it's been great to listen to everyone's ideas.
Thanks, Jess. And isn't that the beauty of collaboration, hey? Helping each other out.
Yeah.
Thank you, and congratulations to the whole team.
Yes. So that's lovely that they assisted you in that way, and that is the true nature of collaboration. Look, I just wanted to say again, thank you to everybody for coming today and participating. This is not the end. This is really the start, and hopefully this inspires a movement and inspires people to go off and fight for change, for disability justice. I wanted to say on behalf of the National Justice Project, thank you so much to all of your team members, the judges, mentors, the audience out there, our sponsors, our supporters, our event partners who believed in this event as a catalyst for change. I also wanted to just a big thanks to the National Justice Project team who worked on this. Tim Ginty, Liz Clark, Ariane, and Katie Tyrrell, big thanks to you for all your efforts and going above and beyond to make this happen. Unless, Ariane, I've left anything out. No, great. I want to say thank you to everyone. Have a great weekend. If you're a Melburnian like myself, enjoy your freedom. If you're so enjoy getting out there and maybe going to an actual cafe and enjoying yourself. Thank you so much for participating, and we'll see you at the next Law Hack.